Welcome everybody to State Policy 101 session, Redistricting, Nuts, Bolts, and Policymaking. I am Wendy Underhill, and I'm the Director of Elections and Redistricting for the National Conference of State Legislatures. I want to begin with a question so we have a bit of a sense of who's in the audience today. And the way you're going to respond is to type your answer into the chat box, and you'll find that chat button to the right of the video player. Okay, so here comes the question. Is this your first, your second, or your third, or even more redistricting cycles where you've been engaged? I mean, I know you've been around for a while, but were you paying attention, the decades that you've been paying attention? So let's get those answers in the chat box. As I said, we did bill this as a 101. So if your answer is my first redistricting cycle, that's just great. You're in the right spot. But if your answer is second, third, or more, that's great too. We hope we'll have something useful, something that's different from how redistricting was done the last time around that you can pick up. I will say that one time I did this question fairly recently, and there was one person who said that this was his 7th redistricting cycle. So that's pretty hard to do. That means he started in the middle of the 1960s and then went to 1970 and onward. So what I'm seeing is that it's a bit of a mix. And I guess based on that nice mix, we are going to stick with the plan that we've got going for us already on keeping it at the 101. For those of you who are in your second, third, and fourth, we will have some experts with us later who you can ask the more detailed questions to if you like, but I think we're going to be good. Okay, now I'd like to talk about housekeeping just a little bit. You've already found that chat button. And feel free to just keep on communicating there, ask, put in whatever is of interest. Some stories from your state would all be good. And then there's a Q&A button. And if we can, let's put the questions into the Q&A. That's because it has that nice feature where you can upvote someone else's question. So if you like what they're asking, we will try to address that earlier on. And then, of course, there is a help button as well. That's in the bottom right of the page. Now, I'd like you to meet my colleague, Ben Williams. He's an attorney who is focused on election law generally and redistricting specifically. He's also a bit of a geek about legislatures, but that is true for all of us who work at NCSL. So Ben, just give a quick little wave there. And as for me, I speak from the perspective of having coordinated the publication of NCSL's Redistricting Law 2020 book, which is now in its 5th edition. I'm going to show you my copy and we'll bring it up at the end because you all can have your very own copy of this tome if you'd like to. All right, so what we're going to do for our next section is Ben and I will go over the top 10 things that we think are important for people to know about redistricting. We'll take questions and comments as we go along the way if we can, but we'll also have some time for questions at the end. And then we will have 3 breakout rooms. And, you know, I've mentioned the Red Book. Well, the 3 real authors of that are Frank Strigari, Jeff Weiss, and Michelle Davis, and they are all with us today. So that's where the real expertise comes in, and they will do breakout rooms towards the end of this. Frank will do a breakout room for those who want to be with fellow Republicans. Jeff will do a breakout room for those who want to be with fellow Democrats. And Michelle will lead the 3rd group, and she's a nonpartisan staff person out of Maryland. And if that's the right niche for you, then by all means go with Michelle, and we'll tell you all about that at the end. So there's only one more thing I want to say, in that if there's only one message you take away today, it's that NCSL is here to support your work in the legislature. So whatever question you have, we want to have you bring it to us first. We handle your questions confidentially, so don't worry that we're going to tell the other party what you're asking about. And we want to be in communication. So if at the end you say to yourself, I got something, send it off to us and let's stay in touch. Okay, that's what I've got to kick us off. And Ben, I think you have number 1. So take it away.
Great. Thank you so much, Wendy. And thanks to everyone for tuning in today. I hope that you get something out of this presentation, and just know that, as Wendy said, the entire team here at Elections and Redistricting is here to help you throughout this entire process. So without further ado, we'll go into point number 1, which is that states are in charge of redistricting. This is no surprise to you. You all know that this is on your plate for the upcoming decade. And the source of the law behind that is the US Constitution. So Article 1, Section 2 of the US Constitution specifically designates the state legislatures as the entities that are in charge of redistricting. And so for decades and for the early days of the Republic, that was where redistricting occurred. Over time, legislatures have changed slightly how they do it. Some states have given that power to a commission, but by and large, the first principle is that redistricting is a duty of states. That is not to say that Congress has no role to play in redistricting. Congress does have the power to establish rules for the creation of its own members, so congressional districts. But if we're talking about state legislative districts, that is a state domain. The second principle we want to talk about is that commissions are increasingly common. The first commission that formed was in Arkansas in the 1950s, or the first commission of a modern sense of the ones that are listed on the screen. And over time, throughout the decades, a couple more are always added. And now we've gotten to the point where in 2020, for the very first time, a majority of states will have a commission involved at some point in their redistricting process. Now, not all of those commissions have the duty of drawing the lines first. Some of them just advise the legislature. Some of those commissions are a backup mechanism in case the legislature isn't able to redistrict by some deadline set in the state's statutes or in its constitution. But it is true that if you looked at the state redistricting systems as a whole across the country, the majority of them would have a commission at some point in the process. And that is very new. Here at NCSL, we are here to support the work of our state legislatures. And if that means that your state has a commission as well, you can tell them that we are here to help them if that's something that they desire. The commissions that are here, you'll notice that there are several of them that are colored in for primary, including states like Missouri and Arkansas and California and Alaska and Idaho. Commission to us doesn't mean what it may mean in popular discourse, which is some people refer to it as independent commission, or some people talk about citizens commissions. Some people talk about political commissions. At NCSL, we don't use that language, not because we don't recognize that there are differences in the structures of commissions. Commissions, like legislatures, are unique in and of themselves in every circumstance. But those definitions don't have common meaning throughout the legislative sphere, through the political science sphere, through the legal sphere. So we just define commission as something that is not the legislature. And that's how we come to this number. And with that, I think we're ready to move on to point number 3, Wendy. Wendy, you're muted.
We spent some time deciding whether the census needed to be number 1 or number 2 or number 3. And you see where it is, but you could say that it really is step 0 of the whole redistricting process. The census matters a huge amount, and it matters, of course, because the Constitution requires an actual enumeration to be made every 10 years. So, you do what the Constitution says. And it also matters because the census determines the distribution of $1.5 billion in federal funding to states and localities. It gets distributed every year for a decade. So it's 1.5, you might say, times 10. And then it matters because the census provides the foundational data used for redistricting. Of course, I'm going to focus on that third point, but let me just hammer the second point one more time. It matters a lot to your local communities how many people get counted, because if money is distributed based on those counts, then they really want to know. So it matters for education and health and transportation. Well, in general, what I'd say is that the census has tended to be a pretty sleepy topic in previous decades, but not in this decade. It has been hot, hot, hot. There have been issues around what data is going to be collected. There have been issues around data quality, and there are issues around delays. And I'm going to focus on the delays because that's what's really throwing the monkey wrench into the state's ability to redistrict. Now, there are 2 kinds of delays I want to mention, and that's because there's 2 major sources of data that you'll be interested in from a redistricting perspective. The first is what's called the apportionment data, and that's the total number of people in each state, so state total population. And when we've got those numbers, then we know how the seats in Congress will be divvied up between the states. Some states will lose, some states will gain. And usually these numbers, the apportionment data, is released right before the end of the year where the census is taken. So that would have been right before January 1st, 2021. but for various reasons weren't able to do that. And now the target date for that is April 30th. So people have to wait 4 more months to be able to figure out how many congressional seats they'll have next time around. And the second data release, which really matters for redistrictors, is the granular data that is provided the smallest unit of geography. In normal years, this data would be released by April 1st, but this isn't a normal year because last year wasn't a normal year. So that data won't be released until July 30th or beyond. And we do not know how much beyond that might be. So stay tuned for that. So why are there the delays? I think the big story, of course, is COVID-19. It disrupted everything last year, including the Census Bureau's ability to be in the field and get its work done. There were some other factors too that added to the delays, but suffice it to say that the Bureau is working pretty hard right now to get on track and get accurate data out to the states. Even so, these delays are causing real grief for some of the states, some more so than others. We have a couple of states that ordinarily would run their legislative elections in the coming November. And because of the deadlines, they won't have data to create those new lines. We have a number of other states that have constitutional requirements for when their redistricting must be done. And I think you're out there, Christy, if you would put our census delays document in the chat, you all could check if you want to what your deadlines are in your state, and therefore determine how much of an issue this might be for you. My other piece of advice is that you might want to talk with your state demographer now or later. First of all, I think they're pretty fun. They usually know how to put on a pretty good show, and they will be able to share with you now, even before the census data is out, where the population shifts are taking place. So you can already have a pretty good idea of which districts are going to need to be smaller in geographic size or larger in geographic size so that they all have equal population. Now, I'm happy to talk about the census all day long and late into the night. So if anybody wants to talk about it with me, let's do it in Q&A or do it after the fact. But for now, I think I'm going to switch over to data matters. So we've said the census matters, and that is the foundational data on which redistricting is done, but it is by no means the only data that's used for redistricting. That's the demographic data. There's also geographic data, and that's the political boundaries and precinct lines. How do we, let's just leave it with those two things. There could be some other things geographic as well that matter. And then there's the election data. Redistrictors like to gather election results from general elections and from primaries and from key special elections going back even as much as 10 years ago. So they get a whole lot of data and they have to have a way to manage it. You might say all of this demographic, geographic, and election data gets brought together into a database. And it's with that database that you can do the redistricting. Now, even beyond those three things, there are some other sources that a person could go to. There is some data that gives more of a survey of some other things that the census itself doesn't ask. It's the American Community Survey. It's not what you'd use to actually draw the lines, but it can give you some additional information for analyzing your lines. And then you can certainly look at commercial data as well. So there are other things that might be brought in, but the three basic ones are the demographic data, the geographic data, and the election results. Now, there is a little caveat. There are a few states that don't use that political data, 4 or 5 states, and maybe Christy, you could get something on that, the criteria page in the chat as well. And then a couple more things I want to say about data before I hand it back over. One is that there will be analysts out there, possibly inside your legislature, but more likely on the outside, who will be using computers with algorithms to create literally millions of maps that they say are legal maps. And these aren't used to make a map that anybody would adopt, but they provide a whole body of maps that become what's called in the parlance of redistrictors now an ensemble of maps. And that might be used to compare the maps that your state draws. So just know that when people talk about ensembles, they're not talking about classical music. They're talking about a way to measure perhaps the partisan tilt of maps being produced in the state. And if your state isn't doing it yourself, people on the outside will be. And then the last point I want to make about data is that some states, and we had 9, and we just had the 10th one join the ranks, will be doing something called reallocation of people who've been incarcerated. So if you can picture that the Census Bureau plans, as one might expect, that they count people where they sleep, then prisoners are counted at the prison address. Well, some states have decided that that's not where they'd like that representation that goes with that person to be. And so they're, you might say, taking that person's data and putting it back to their former home address. That's a tricky data thing. And like I say, 9 states are doing it. We just heard that Illinois has gotten it through the legislature and is waiting for the governor's signature. So that would be 10. So that's more like a hint. You want to talk about prisoners, happy to pick up on that further as well. But I think that's it, Ben. Anything I missed? And if not, then go ahead with public input. Excuse me, with the next slide.
No, Wendy, that sounded great. Thank you. I don't have anything to add. That was everything data you need to know. And if anyone has further questions, we've got plenty of Q&A and some breakouts later where we can dive into this further. Trust me, when we do these redistricting seminars, we have entire sessions, hours and hours just on data. So this is something that deserves more time than an hour can give it, but I hope that the highlights are giving you the little tickle you need to dive into this a little bit further. So now we've covered who's in charge of redistricting, and we've covered the kinds of data that are used to do redistricting. I think it's time to start talking about the rules of redistricting. What are the federal guidelines that regulate how the process works? Are there any state rules that govern how redistricting works? And I'm going to take the federal part, and then I'm going to hand it back over to Wendy for the state part. So the first principle that you need to know is that equal population is the predominant issue. So equal population, you may know it as one person, one vote, comes out of a series of cases from the 1960s. And it's a principle that a individual in a district should have an equal say in the election of legislators or people to legislative bodies. That means Congress, that means state legislature. You go on down the line, it means county commission, boards of education, anything where an elected body has members that are elected, one person, one vote applies with a few minor exceptions. The principle has evolved over time. We've learned a little bit more about what exactly equal population means. So for example, we've learned in more recent cases that one person, one vote in the case of congressional districts means exact numerical equality. So you need to get it down to a person, and any deviation from exact numerical equality requires a legitimate state interest that the state can articulate in court when the state is sued for said deviation. And those reasons have been upheld in some cases, but just know it's a very rigorous standard. In the case of legislative districts, there's a little bit more leeway. And if you think about it, it makes some sense. Legislative districts, with a few exceptions, tend to be smaller than the size of congressional districts. And when you're dealing with smaller units of geography with smaller numbers of people, the traditional criteria that Wendy will cover in a little bit that states use to redistrict could be harder to comply with if person for person equality is mandated. And so the US Supreme Court has said that as long as you have within plus or minus 5% deviation from the ideal district population, and ideal district population is a simple calculation. It's just population of the state divided by the number of districts, ideal district population. As long as you're within plus or minus 5 of that, it is per se constitutional, although people can still argue whether or not that should be upheld in court, but there's some rules about safe harbor that go along with that. The last thing I want to say about equal population is that the US Supreme Court has said that it's not a principle that is weighted against other principles. So you couldn't have an argument, for example, about equal population versus compactness or something like that. In a case that the Supreme Court decided in 2015, they said that equal population is a threshold rule after which the rest of redistricting occurs. So this is not something that can be balanced against other factors. Equal population is the first principle of redistricting. The next one is a little bit trickier. States must balance competing race principles. And I'm just going to walk through this briefly to give you an idea of why this is somewhat complicated for states. So we're all familiar with the Voting Rights Act of 1965. Landmark civil rights legislation created new federal standards for how redistricting and elections and all sorts of other democracy-oriented things work. The principles that applied to redistricting were Section 5 of the Voting Rights Act, which was the pre-clearance regime that is no longer in effect in any jurisdictions. So for your purposes, what you need to know about is Section 2. And Section 2 applies nationwide. It says that the districts must be drawn to give minority groups an opportunity to elect their candidate of choice if a certain number of factors that the Supreme Court has articulated are present. So obviously, to know if you should be drawing a district under the Voting Rights Act, you need to be able to look at the underlying data that would require you to do so. So race data, political data is involved in this as well. On the flip side, you have racial gerrymandering doctrine, which emerged out of the 1990s in North Carolina. The district you see on your right is actually the original racial gerrymandering district out of North Carolina. And this doctrine is based in the Equal Protection Clause of the US Constitution, and it holds that it is illegal for race to be the predominant factor in the creation of districts. And you may ask, well, Ben, how am I supposed to comply with that? You've just told me that I have to consider race for compliance with the Voting Rights Act, but I'm not allowed to consider it predominantly, or else I'll get sued for racial gerrymandering. And that's an excellent question. And it's a delicate balance that states have to thread the needle on. And so the way that it's worked is the Supreme Court has said that if the Voting Rights Act was the reason that a state drew a district in a particular way, and they didn't use race predominantly at all beyond the construction of that Voting Rights Act district, then that is an affirmative defense of sorts that states can argue when they're the defendants in a racial gerrymandering lawsuit. Apart from that, the Supreme Court will strike down districts for the predominant use of race if it is not strictly required by the Voting Rights Act. And so this is one of those things where doing some analyses of whether or not the Voting Rights Act apply can be really critical to upholding your districts down the line when, as I mentioned in a little bit, the state will inevitably be sued. But with that, I'm going to turn it over to Wendy for the state factors that are relevant here.
Ben, before we move to the state factors, I want to ask you if this is a good summation of your last two slides. Are you ready?
Yes.
Redistrictors must make districts equal in population and can't discriminate. Those few words capture it?
Yes, that is, if we're talking about that few words, that is an accurate summation. As an attorney, I have to tell you, Wendy, my instinct is just to drone on forever and ever about all of the complexity, but your succinctness is helpful here, so yes.
I'd almost looked at it like a haiku when I wrote it down here, so I thought I'd share that. Thank you. Okay, so talking about the state requirements. First, we're going to follow the two that Ben has just laid out, one person, one vote, and balancing racial principles. But then states are free to create their own standards, and they have created their own standards, and they live by those own standards. And you can call them criteria or priorities or principles or guidelines, whatever word you like, but there are rules to live by in your state. Some states have 6 or 8 of these, others have very few, possibly even none beyond the federal ones. But knowing what they are will matter as you go about the business of redistricting. So I'll call your attention to just a few of these. Some are geographic in nature. For instance, it's very common to ask that the districts be compact. And we all have a sense of what compactness is. A circle is more compact than a star, for instance. But there are also mathematical measures, but the eyeball test is sometimes what's used. Fine point here, if you go back to what we just learned about race, sometimes districts can be made in a way that is not compact, but it's built for a specific reason. So if you see an odd shaped district, don't assume anything. Just ask, why did it get built that way? So we've got compactness, contiguity. That means that it has to all be one entity. You can't have any outlying parts that aren't connected. You can't have any donut holes in the middle of anything. And then preserving existing political lines, such as county lines. Now, it's absolutely impossible to have equal population and have all counties held whole, but you can count how many counties got split. And the fewer splits, generally speaking, courts are more favorable towards than many splits. So those are things that are kind of measurable, you might say. Then I'd say in the last decade, there's become more interest in one called preserving communities of interest. Now, communities of interest is a term of art in the redistricting world, and no one really knows what it means. And that's kind of part of what makes it interesting. To know what is a community of interest means to go out and ask people, what is your community of interest? You could think of it as a neighborhood. You could think of it as a community, but it's more than that. It could be where economic interests or social interests are whole and don't necessarily fit within political subdivisions. So examples would be rice farmers in Louisiana, commuters in DC's bedroom districts, or Native American tribal lands, or in fact, not just the tribal lands, but Native American communities more broadly. So to figure that out, you got to do some thinking in advance. And then the last thing I'll bring up is that there are what we are calling emerging criteria. And these have been aimed at addressing politics in redistricting. And there are several different ways to do it. And there's no agreement on this. And here too, you can look at what your state statutes or more likely constitution require. One is some states ask that districts be made competitive. And some ask that the districts, or the statewide plan rather, mirror the approximate Democrat-Republican split in the state. And some may say that you can't favor or disfavor a party or a candidate. I just want to say that all of these bring the attorneys back to the table. How do they balance against other criteria? Can you do both competitiveness and preserve communities of interest? I don't know. And so there's a lot to be seen about, are they prioritized or are they all standalone? In which case you can argue about which one you want to pay most attention to. And then I guess another thing I could offer is that these are set primarily in constitutions and in statutes sometimes, but if your state does want to change or review their principles, they can still do that. There could be a statutory change, or more likely a committee that's doing redistricting might adopt some guidelines at the beginning of their work together to determine either adding to it or prioritizing them, or recognizing how they plan to go about doing that. I think that's good on state rules. Back to you, Ben.
Great, thank you, Wendy. So I'm going to talk now about how courts are always busy with redistricting. And for those of you who follow redistricting, this is not news or a surprise. Redistricting tends to take 1 year, maybe a year and a half at most, and then the next 8 years are spent in court. And so when you think about it through the decade, this is the phase that states are in most of the time. And we've already talked about equal population. We've talked about the Voting Rights Act. We've talked about racial gerrymandering. Wendy's talked about criteria. Those are all things that do end up in court. So those are included within this. I'm not going to go into those again. I'm just going to touch on the things that we haven't addressed yet. What primarily is the doctrine of partisan gerrymandering. And I'm sure that many of you are familiar with these partisan gerrymandering cases that were prevalent in federal courts in the 2010s. They emerged from several states. They argued slightly different theories. Some of them were only addressing individual districts. Some of them were addressing entire statewide districting plans. And they went up to the Supreme Court in a couple of ways. But the important takeaway is that in 2019, in a case called Rucho versus Common Cause, the Supreme Court said that partisan gerrymandering cases were political questions that were outside the ability of federal courts to redress. So they were non-justiciable in the language of the Supreme Court. That closed the door on these partisan gerrymandering cases for the foreseeable future. The Supreme Court could always revisit its decision at some point, but for now, that path is foreclosed. In that opinion, the Supreme Court did say that state courts were an acceptable way for people to seek redress for excessive partisanship in redistricting. And they cited an example out of Pennsylvania, which emerged in 2018. In that case, the Pennsylvania Constitution had a clause in it that said that all elections shall be free and fair, free and equal. The 30 states have variations on this language, but it's called a free and equal election clause. And that had never had an application to partisanship and redistricting before, but a group of plaintiffs in Pennsylvania brought a lawsuit saying that that clause included within it a prohibition on excessive partisanship. And the Pennsylvania Supreme Court agreed and struck down the state's entire congressional districting plan as an unconstitutional partisan gerrymander under the state's own constitution. And what's interesting about that is there is a doctrine at the US Supreme Court called the Adequate and Independent State Grounds Doctrine. It's been around for decades. And it says that if a state Supreme Court interpreting a state's own constitution without reliance on any federal rules or guidelines occurs, the loser at that state Supreme Court cannot appeal that judgment to the US Supreme Court. That path is foreclosed. And so, as a result, any of these cases, if state Supreme Courts rely solely on their own constitutions and there are no issues of federal law involved, that's the end of the case. And the US Supreme Court can't take it up and then use their holding in Rucho v. Common Cause to say that this is a non-justiciable political question. So, as a result, there is a possibility that these cases, the one in Pennsylvania, another one emerged in North Carolina in the past couple of years as well, could move on to the other 28 states that have some version of a free and fair, free and equal election clause. And we'll have to wait and see whether or not that happens. But I bring it up to your attention because it is a new and emerging trend in redistricting litigation that could, even if it doesn't necessarily expand, these are 30 state court systems wrangling with 30 state different procedural rules and different interpretations of constitutional history. It's not like every state's going to come to the same conclusion, but there is a possibility that there could be a significant amount of litigation in state courts under these clauses in the coming cycle. The ninth point we want to address is public input. And this is something that you've probably heard a lot about in the press and from others. And there's a couple of different ways that this can manifest. The two most important ones, I think, for our purposes are public hearings and public comment. So public hearings includes the submission or the public hearings include the ability for the members of the public to come to a redistricting entity and say their piece. And traditionally, the way you would think about that is it's a legislative hearing in a legislative committee room at the state capitol. And the people would come up to a podium and say their whatever they would like to say. I think that's the most common method. If you're in a commission or you're in a state where the legislative committee goes around the state and holds hearings on location, that could be what's happening as well. And if you think about that, those committee rooms, at least the ones I've been in, are not very big. And it's typically hard to maintain social distance, if that's the rule of your state, and hold those hearings. So there is a question of whether or not the COVID-19 pandemic will change how states handle these public hearings. And if you have a plan in your state about how you're going to hold those, we would love to hear it, because that's one of the most common questions that Wendy, Christy, and I have gotten from our members, is asking what other states are planning to do to adapt their public hearings for redistricting in light of COVID-19. Wendy and I are based in Denver, Colorado. It's been warm recently, but if you just picked a random day on the calendar between November and April, you probably wouldn't want to hold that hearing outside where outdoor meetings are safe. Maybe that's a possibility in Louisiana, where I used to live, but it is certainly not a possibility here. So every state is going to have a different solution to this, and I would like to know what exactly your state is planning. And if your state doesn't have a plan yet and you want to talk to us about it, we would love to bounce ideas off of you or connect you with folks in other states who are starting to put together blueprints for how they're going to address this, to see if any of the lessons that they've are trying to apply can translate over to your state. The second point is public comment. So this can take a couple of forms. It can take the form of the person at the podium in the committee room that I just mentioned. It can also be completely digital. And there are several states that have had in the past these portals that are set up online, where members of the public can log on, create an account, and using some sort of online redistricting software, it's usually a stripped down version of whatever the state has purchased the license for, can draw either their community of interest or a partial map or a complete map and submit it to the legislature or the commission for their consideration. And in the states that don't do that, we have a new entry to the field, which is the screenshot you see on the left-hand side of your screen. There are these free online redistricting tools that are available. There's several of them. The example I have on the screen is Dave's Redistricting. It's something you may have heard of before. And anyone can log onto this website and create an account. I have an account on Dave's, and you can draw a districting plan for the entire state using the data that is just stored on the website. And then you can export that file and submit it via email to the legislature. And this is something that's going to be coming to legislatures, whether or not they have a system set up to receive it. One state that has set up such a system is Oklahoma. The Oklahoma legislature has created a legislative email address specifically for receiving these public maps. And at that point, the legislature has a process for sorting and organizing them into map type and whether or not the map complies with all of the rules in Oklahoma, and then it goes on for further consideration. But this is something that you should be aware of. You will be receiving these maps in your inboxes. So just know that this software exists and it could be coming your way. With that, I'm going to hand it over to Wendy for our final point and some resources.
I'm going to ask you another question though, Ben. Supposing you're not as detail oriented to want to get in and actually do redistricting on Dave's or other software, are there some games or other ways that people can like get some flavor for it before they dive in deep?
Games or other things. There is there's an online game called the Redistricting game, which is somewhat more rudimentary, and it's not designed to be like redistricting software. It's just designed to give the user some familiarity with how redistricting works. You get to physically move lines back and forth to achieve the objective of the level. And then I'm sure that we can put that in the chat. And then there are some other tools. Not all of these free software tools require people to draw an entire map. Some of them are focused solely on gathering data on communities of interest. And the ones that I've seen before, demoed, the way it works is it's essentially a Google Street View overlay. So if you've ever used Google Maps for anything, you'll know what that grid looks like. And then you just zoom down and you just trace the area on the map where you think your community is. Obviously, that doesn't require any sophisticated map making capability. It just requires you to be able to know how to draw a circle or a star or whatever else on a screen and then submit it. So there are levels underneath the full map making capability, but I think that just goes to show that there are a lot of these tools popping up online, and community groups are making their folks aware of these. So this is something that will probably only become more known in the weeks and months to come.
I'm thinking that if people like fantasy football, they might like fantasy redistricting too, and you've given them a couple of ideas on that. Okay, what I'd like to say about politics is that it is hard to take the politics out of redistricting, and it's hard to take redistricting out of politics. These two things are hand in glove. And that's because how the lines are drawn has consequences in terms of who gets elected. And who gets elected has consequences in terms of the policy choices that a state makes. So we're not trying to avoid the fact that politics is important. We will acknowledge that both major parties would like to get maps that are advantageous for themselves in the states. That's a given. You've got two teams and they do squabble over the districts for sure. It was true when modern redistricting got started in the 1960s, and it's true now. It's possible, a lot of people say that it's more of a push-pull, more of a battle than it used to be because it's easier to slice and dice the data more finely, but it's always been a political activity. So who holds the reins right now? What I've got up here is a map of state control, and this is who holds the legislatures and the governorship. If it's that steel blue, I don't know, steel gray, that's Democrats. If it's the burnt orange, it's Republicans hold the Senate, the House, and the governorship. Now, ordinarily we use red and blue. We're changing or trying out this new thing. If you all would tell us whether you like the new color palette or if for politics we should stay with red and blue, that would be great. And we can go back, if anybody wants this kind of detail, we can go back and show you slides of what was partisan control in 2011, the last time redistricting was done. And there are other factors besides who's in those three power positions. And those, for instance, are, does the governor have a veto? In North Carolina, the governor doesn't have a veto. And does the legislature have veto power over the governor. So in which case the veto is much lessened. And then of course, the many states that Ben talked about earlier where a commission is doing it. And just because a commission is doing it doesn't mean that politics doesn't matter. Many of the commissioners are appointed by legislative leaders with a political intent there. So yes, politics is part of it. And if you're on the majority side, that doesn't mean you get everything you want. And if you're on the minority side, it does put you at a disadvantage perhaps, but there are still going to be some ways that you have a role in redistricting. And we can talk about that further too. Jeff, I'll ask you about that when we get to you. Okay, let's look at resources. And then I'm going to bring our three special guests on in a moment. So NCSL spends a certain amount of its time working on redistricting, and that's because we see this as a core legislative function. We've been doing redistricting seminars in the past. There was a set of webinars in May last year that are still available online if you'd like to see them. We may easily be having an additional seminar coming up. The dates aren't decided on that yet, and it's partly dependent on whether that census data we talked about comes to us or not. And then I mentioned the Red Book, 282 pages, 10 chapters, 9 appendices, good doorstop, that's one function for it. Also is filled with really, really great stuff. And it's so carefully vetted by Michelle and Jeff and Frank. So you can kind of stand on it. Although it's fair to say that the census chapter is already out of date because the census data didn't come when we thought it would. You might like to start with just the executive summary that's pulled out in a separate document, and that'll be in the chat for you. That gives you a really nice overview of the key points that we've made here today and are important for redistricting. And then I'd like to say that we do have lots of other web pages. So if you've got a question, we've probably got an answer. And then the last thing, and probably the most important thing in terms of resources, is that Ben and I and our colleague, Christy Zamarippa, who's on the other side of this webinar with us, are all available to answer your questions. So please feel free to ask. That's kind of where I want to end our formal presentation. I don't see questions from the audience, so I'm going to ask a couple of questions for our experts. And Michelle, I'm going to start with you. This is Michelle Davis out of Maryland. And could you tell us a little bit about legislative privilege and perhaps the attorney-client relationship and what that means in terms of redistricting?
Well, I won't go into great detail, but what I can say, especially about legislative privilege, is that in this past decade, litigation has shown us that courts are willing to limit legislative privilege. And the problem with sort of understanding if down to an individual level, say you're in your own state and you're trying to figure out what's going to be scrutinized perhaps later in court and what's going to be protected. My best answer to you would be, well, you don't really know because legislative privilege is sort of getting interpreted in all 50 states. So there's no sort of national standard for legislative privilege. There is the trend, however, and the trend is that judges have been, I don't want to say eager, but they have limited its scope. And what that means practically is that a lot of things that you thought might have been covered by legislative privilege, emails and other types of communications and things like that, you now have to consider that they won't be covered by the privilege.
Thank you. That was succinct and wonderful. Frank, I want to ask you, how can a state avoid getting sued? Is it possible? What would you do?
Well, I mean, to be honest with you, I would say there's probably, a state will probably most likely always get sued when it comes to this process, unless you're in a state that just is entirely one party rule and dominated, which I don't think is very much any states. I think in Ohio, there's literally been a lawsuit on either state legislative or congressional districts for at least the past 6 decades. I wish I had better numbers on that, but it's at least 6 decades. So it's sort of hard not to get sued. But I would argue though that the best thing we just knowing from our most recent litigation that happened this past decade, the privilege issue that Michelle was just speaking of, I think is something that is very significant that everyone should always keep in mind, is that whatever it is that you may think you can or should or should not be putting in writing, the best advice to ever take, I can ever give to anybody in this area is you should just be putting stuff in writing that you think needs to be put in writing, that is official, that you know will always be looked at for probably 10, 20 years later, because somebody has kept that email. The courts will want to look at that email. And as Michelle was just saying, there's probably not one area of more so than redistricting that courts allow greater access and scrutiny to in litigation than redistricting. And so official records should be official records that you think will always be looked at into the future. Don't say anything, or don't crack jokes. Don't use any terminology that you wouldn't want anybody to ever not see in the future, because that will ultimately wind up coming to be brought against you, and even though if it's taken out of context. So be careful with what you're putting in writing. Be careful what you're saying in public. Be careful what you're saying at committees. Stick to the rules that govern an open and fair process. States should always allow for the greatest transparency when it comes to redistricting, because the less you have, the more questions there will be, and the more likelihood there will be for litigation. So those are just a couple little nuggets. Hopefully that might help.
Totally, absolutely. It makes me realize that that's why redistrictors don't tend to be the funniest people in the world, because they've learned not to tell jokes because it'll be used against them later on.
We're all funny. Come on.
Well, you're pretty funny, I gotta say, but not when you've got your official hat on. Jeff, I'm going to come to you in a minute, but Ben, would you answer Tim's question about whether a religious community could be considered a community of interest?
Yes, of course. So communities of interest doesn't really have a definition at all. I mean, some states do give it at least a partial definition so that there's some idea of what exactly it means. But in general, the way communities of interest works is it's either what someone in the legislature or the commission thought about, or it's what at a public hearing, someone asked, hey, what's your community of interest? And people told them. So it's not the case that they are necessarily included or excluded from the definition of communities of interest. I will say that there could be protections for religious minorities and the law that's related to that in some other way. But in general, the way it would work is if there was a definition of communities of interest that was established in state law, or a particular religious group came to a public hearing, for example, and said, we are a community of interest, we are distinct, and we should have representation in the legislature because of these distinctions, and the legislature agreed with that, that could be the establishment of a district around that group for communities of interest reasons. That's just to give you one example. There are certainly could be situations in which the establishment of a district solely on religious grounds could create some legal scrutiny under different provisions of the law. So I'm not saying that anyone should go out and just start creating a ton of religious minority districts, but it is something that could be done under any definition, because in most states, communities of interest doesn't mean anything in the law. It just means whatever the redistrictor says it means.
Excellent, thank you. Jeff, you've been around for a little bit. Could you give us the broadest brush view of how redistricting has changed from 1970, the first year that all the states were doing it, in the modern era? What's changed? Is there a decade to decade shift?
Sure, I'd be glad to answer that. Let me just mention before I respond, just to emphasize what Ben just discussed, that I'm from New York originally, and there are religious communities of interest where districts are drawn to specifically observe those kinds of community interests. The Supreme Court even discussed this in a case in the late 70s. You can contact me directly offline later. I can get into this more specifically, since it is a bit of a unique issue in New York. What's different? Well, redistricting has often been called the blood sport of American politics. And since I guess by the audience here, you're new legislators, new staff, we don't want to scare you away from it, but from the old blood sport of American politics to 2021, what we're seeing now is redistricting under a microscope. that we've never seen more press attention, good government, civic group and interest in redistricting. You're going to see an awful lot of press on this. You're going to see more public involvement than you've ever seen before, and that's different. So what used to be something that took place in the proverbial smoke-filled back rooms is now out in the open sunshine. And Frank covered a few key points on what you say. There's an old phrase from World War II, loose lips sink ships. So be very careful what you say. We're going to have a much more transparent process. And getting back to my colleagues' comments, if you don't have a fair, open, transparent process, and also very important that because of the limited time available to us, given the late delivery of census data caused by the pandemic, we don't want to see plans rush through legislatures in just a few days' time. So we'll see that happening. And overall, we also have, as Wendy mentioned in her presentation, these new ensemble plans. None of us ever contemplated those kinds of plans, not really until 2017, when a professor at a New England university started to teach redistricting to mathematicians, which we never heard of before. And I'm going into my 5th decade of line drawing, so there are new things. And I'll just end by saying, expect the unexpected. You're new to the legislatures. There will be reasons why you should or shouldn't be involved in the process that your leaders will hopefully talk with you about. But if you have any questions, you could always come to NCSL as a fair, objective resource center to learn about at least the basic law, the basic process, the whole basic soup to nuts of redistricting. So good luck.
You can tell that the 5 of us know each other pretty well, and we like to work together. And one thing I'm noticing is that Frank, Jeff, and Michelle all reinforced the part about privilege and the loose lips. All of you wanted to double down on that. So if there's one message people are going to take away today, I'll bet it's going to be that. Frank, I'm going to ask you a question, and then we're going to go to the breakout rooms. And the question comes from Representative Jennifer Day in Kansas. If a state is going through redistricting lawsuits for an extended period of time, how does that impact elections?
Well, it depends on, okay, so I guess we'll use some examples from here in Ohio. Is that, when we had at the beginning of the last decade, we had, filing deadlines coming up for congressional candidates, and actually even the statewide candidates back then too. If you don't get the plans in place before then, you've got problems. If the litigation is pending and also creating more problems, it depends on, of course, what the litigation and what the judge is probably even ordering though too. So I don't know if I understand the full context of the question, but if you have pending litigation that's going on, it's going to create a lot of problems for the upcoming elections. And then the question is which districts are we looking at? Which districts are we talking about? And so I don't know if you have a little more context of the question, Wendy, but
no, I don't. But I'm guessing
it creates a lot of problems in many different aspects for which you probably can't even begin to even think about. So
right. I'm guessing that Representative Day may meet you in the Republican breakout room. But one thing you said I don't know if I really said this as forcefully as I wanted to, and that's that when redistrictors are done, there's a whole process that election officials have to do before you can get to the candidate filing deadline. So I think we often, when we're thinking about redistricting, we say, oh, got it done, made a map, done, go have the cocktails. But that's not the end of the story. There's a lot more that has to happen before you run that primary election, before you get to that next general. So being conscientious about the folks on the outside is good. Okay, it is time for breakouts, and they are labeled at the bottom of your screen as Democrats, and you'll be meeting Frank over there you'll be meeting Jeff with the Democrats. Republicans, you'll be meeting Frank, and nonpartisan people, Michelle. And there's nothing special. If you want to go to the opposite one, that's fine. There's no trying to control this. And let's do that. See you all in the breakout rooms. And thank you very much for being with us.